The next case is State v. Farakhan, or Farakhan, if I'm mispronouncing, I apologize. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
5.
Very good. I'll be keeping that time up here, and you can see it over there on your left on the clock. So as that top button gets to 5 minutes left, that will be your rebuttal time. I'll try to give you a warning about a minute before that. Counsel, I'll try to give you a warning about a minute left in your time with that police, so you know that's coming up. The arguments are being recorded, so when you come to the podium, first please introduce yourself. Please stay behind the podium and speak loudly so we can get the recording, and if you move, we'll lose you, so please stay behind the podium. You should not use the name of a child, minor, or victim. In this case, don't know it would come up, but if you would, please use initials or a designation such as victim or child if you would do that. We read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. My name is William Norman. I represent the appellant Nia Farakhan in this case. I'd like to reserve my 5 minutes for rebuttal. Members of the panel, my colleague, participants in the court. We stand before this court on a matter of grave importance, not just to Ms. Farakhan, but to the integrity of the justice system itself. This is a case of a woman who has proclaimed her innocence from the very beginning of this case and maintained her plea of innocence even as she puts in her Alford plea. Ms. Farakhan is not a career criminal. She is a mother, a college graduate, a social worker, and a caregiver who for years entrusted her home to the care of children without a single complaint or blemish on her record. She has no criminal history. And yet, we are coming here today saying that she pled guilty to an offense where she maintains her innocence. And so the fundamental question that raises is why would an innocent person enter this guilty plea, waiving her right to trial? And we'll go through that here. My client makes two distinct claims. First, that my client, trial attorney, failed in due diligence and to inform her of the existence of an expert, Dr. Smith, who could have been used to buttress the prior expert that was offered, Dr. Joseph Scheller. I'm going to get into the facts just a little bit. I know the court is familiar with the briefs. But this case is about my client who was watching a young child. This young child's mother came. They looked over, and the child was exhibiting symptoms of a sense of seizure. They called the ambulance. The EMT brought the child to the hospital, and later it was determined that the child had a brain bleed. The government's experts have no direct evidence that my client did anything to this child. But based on the government's expert, which says that this injury had to be caused by a car accident level trauma and had to have been done near immediately before the symptoms manifested. Dr. Joseph Scheller, a nationally renowned expert in this field, has been admitted to give expert testimony in dozens, if not hundreds of cases by now, was offered as the defense expert. He was not denied based on the fact that he's not a qualified person, but rather the trial court said that, well, your scientific literature is wanting in supporting these opinions. Basically saying you didn't give me enough science to support the opinions that you're making. And so it was incumbent upon the defense counsel to look for an expert that could buttress that deficiency. That expert was readily available, Dr. Smith. We've given his expert report, but his expert report confirms and supports with ample scientific literature. There's no argument on the other side that says Dr. Smith's opinion would be otherwise, unsupported by scientific literature. That says not only does the injury not have to be a car accident level impact, but it also does not necessarily have to be immediately before the onset of symptoms. This is the expert, Dr. Smith, which should have been found, and with due diligence would have been found, had the trial counsel did what he needed to do. His failure in that due diligence, and his failure to inform his client of that expert, is an error. Now, the court does not say that the expert testimony in Dr. Smith's report is wanting in any way. Instead, the court focuses on a kind of semantic interpretation of our claim where the court's essentially saying, your claim is that you didn't know you could hire a second expert, but you could hire a second expert. We gave you funds for that. That's not the claim. The claim is that you didn't find this expert, didn't tell me about this expert, which actually would have supported Dr. Joseph Scheller's admission as an expert. So the court's reliance on this kind of semantic reading of the affidavit instead of obvious thrust of the claim is why the trial court's decision must be reversed. My colleague offers nothing really else to try to explain why the expert's opinion should not result in a new trial. Merely, they say, well, all she was saying is that she didn't know she could hire another expert. Because we gave expert funds, that takes that claim out of the picture. But the claim was about this expert. And not only was he readily available, he's the first name given by Dr. Scheller. He has testified in dozens of cases himself, in similar types of matters, even with Dr. Scheller sometimes as a team. And so now I imagine that my colleague, if I were to raise this on Rule 33 and say, hey, this is new evidence, what would they say? They would say, you could have gotten this with due diligence. So we're stuck between a rock and a hard place. Either the attorney could have found this expert with due diligence and has been ineffective for failing to do so, or the state can concede that this was not even available, even with due diligence, in which case I'll be filing my Rule 33 tomorrow. Your Honor, the other type of the claim that my client has put forth is that she was both misinformed and uninformed. So in this battle of experts, where an expert was critical to the case, she was disarmed. So despite that, she still proclaims her innocence. So why did she enter a guilty plea? And even though it was an Alford plea, why did she enter it? First of all, she was misinformed as the amount of time she was facing if she were convicted at trial. Both the trial court said 19 years, the trial counsel didn't object to that, which was incorrect, and he never discussed the issue of merger with my client, as shown in the affidavit. So she thought she's facing 19 years. So when the plea agreement comes down and says, we promise we won't ask for more than 8, it sounds like a real downward departure from what her maximum was. But when you consider the issue of merger, she was only facing 8 years anyway. So she takes an Alford plea, maintaining her innocence, so that the government doesn't ask for more than they lawfully could. That is misadvice. Now, on 26B, we raised that. We said it was plain error for the trial court to fail to give this misadvice. And they said, well, it's not the trial court's job. Well, then it must be the attorney's job. And the attorney's failure to do this is obviously an error. And my colleague doesn't argue otherwise. My colleague, like the trial court, argues instead, well, we can't take her affidavit as anything. Zero weight to that affidavit. And what's that based on? It's based on a single statement. It's based on the statement during the plea colloquy where the judge, and practicing attorneys all know this question, are you satisfied with your counsel's performance? Are you satisfied with the advice your attorney's given you? And when she says yes, the judge takes that as a general and blanket denial that anything could possibly come up in the future that could change whether or not he's ineffective. And that just, it doesn't jive. It's circular logic, and it's a post hoc rationalization. The idea, when she's sitting there asking that question, answering that question, she's answering the question from a perspective of what she knows at the time. What she knows at the time came from her attorney. It's a closed circle. Of course she wouldn't know what problems were going on with her attorney. Her attorney's the one telling her about the law. And so the court uses this general statement and says everything in her affidavit is discounted because it's a self-serving affidavit, and she already said that her attorney was, she was satisfied with her attorney. And so therefore, it acts as a specific denial to all of these other things that she wouldn't have known at the time. She didn't know about the existence of Dr. Smith because her attorney didn't go find him. She didn't know about the issue of merger because her attorney never told her. How could she, at that moment, when she's asked that question, say anything but, yes, I guess so. I don't have another source of information. The judge is telling me I'm facing 19 years. That jives with what my attorney is telling me.
About a minute left in the initial time, counsel.
And so, Your Honor, at the end of the day, this is not a case where I'm up here arguing procedure for someone who is obviously guilty. I've done that case. I'm not arguing for suppression of good evidence that would show that this person, did the crime committed. I've done that case too. This is a case of an innocent person maintaining her innocence the entire time during her trial. And not only are her claims not contradicted by the record, which is the standard. They have to be directly contradicted by the record before you can throw out that affidavit. Not only does it not contradict, it supports. Number one, it supports the idea that she was told that she was facing 19 years when she obviously wasn't. Number two, it supports the idea, in her sentencing, she's talking about communication problems with her attorney, and the idea that a single question, generally speaking, about the attorney at the time, from the perspective of where she's sitting, somehow acts as a future denial of anything she might learn, the logic just doesn't hold. Ask my colleague how to explain that, because I can't. I cannot. Your Honor, I will save the rest of my time for rebuttal. Thank you.
Good morning, judges. May it please the court. Again, my name is Rick Raley. I'm an assistant prosecutor appearing on behalf of the appellee of the state of Ohio and Summit County Prosecutor Elliot Kolkovich. I want to reframe a little bit where we are in this case. We're not here after an evidentiary hearing. We're here at the pleading stage in post-conviction relief proceedings. And there is a gatekeeping function that a trial court has during that pleading stage. And the judge in this case exercised that function because the only evidence that was attached to the petition included the affidavit of the defendant herself. She is the most interested person in the success of her petition. That is a reason to discount the credibility of her assertions. Her allegations in that affidavit contradict not only her representation during the plea colloquy that she's satisfied with her trial counsel, but also about whether there is available expert opinions to support her cause. They obtained one opinion that was excluded during pretrial proceedings. There was another expert who was retained and received a substantial fee from the trial court as an indigent expense. So there were attempts made to obtain another expert opinion. Sure, there was not one that they finally wanted, but there were two attempts made. And I also want to point out that it's a situation here where post-conviction, this is not about retrying a case. It's a limited remedy that's provided. It's something where there has to be some sort of grave injustice that is reflected here. Having a constant second bite at the apple and retrying until you finally find one of the thousands of doctors in this country to give you an expert opinion you want is not what a district post-conviction relief is designed to do. And I would point out all of these issues about the colloquy could have been raised in the direct appeal. They were actually raised in the motion to reopen that was filed in the direct appeal. And at this point, they're completely res judicata. In regards to any misadvice, if the court wants to delve into the merits of this, which I don't think are appropriate because of these res judicata issues, look, she got a 5-year sentence, so whether she thought it was 8 or 19, it doesn't have any impact on what actually happened in the case. So I would start with that. I'd also note here that other areas about how the trial counsel handled the Daubert hearing are all clearly on the face of the record and could have been raised on direct appeal. To the extent that we're going into battle of the experts, I think it's inappropriate for this court or the trial court to do it at this point because we aren't at that point. So I'm not prepared to respond to those allegations. That's why I didn't, because it's inappropriate. But unless there's any questions, I think that this is one where you have to defer to a trial judge's assessment of this case. And it wasn't just during that plea colloquy. There were multiple pre-trials. And having appeared in common pleas courts many times here in Summit County, there are times where judges will raise, hey, there's something here that we're missing. Or you, a defendant, are appearing in front of me, and it appears as though your body language, what you're saying, what you're doing in the hallway indicates to me that there's some sort of concern with what your trial lawyer is doing. Nothing like that appears on the record. I'd also note that this isn't the case, and we've seen it in other post-conviction cases, where the trial counsel himself or herself files an affidavit saying, yeah, I misadvised my client this way. That does not exist here. All we are relying on is the word of the defendant herself, who has every reason to try to get out of her sentence. So with that, I'd ask you to affirm the trial court's position, unless there's any questions. Thank you, judges.
Thank you, Your Honor. First, I want to go to res judicata. The idea that you could have raised the issue of Dr. Smith on appeal, I mean, it's just not true at all. We had to go get the expert opinion. If we would have said, hey, there's a Dr. Smith out there who we could use, my colleague would rightly say, there's nothing in the record that says that. So we have to create the record. That's what post-conviction is for. Additionally, when we talk about the errors in the colloquy, there's two sets of errors. There's the error that the trial court committed in giving her the wrong amount of years. And then there's the error of the trial court counsel, which failed to inform her. We did raise the issue of the trial court judge on 26B, and they said, well, that's a change in the law. The court isn't responsible for that. But still, of course, the trial counsel is responsible for analyzing the situation of merger and advising his client appropriately. So if it doesn't lie with the trial court, surely it must lie somewhere. We can't expect people to go into pleas and not have any idea that actually, and my colleague says, oh, it doesn't matter if she was facing 9 or 18 because she got 5. Why would she plead to I won't give you more than 8 if she was only facing 8? That's how it applies. It doesn't apply to the ultimate sentence she got. It applies to the inducement to make her plea, which is what is at issue here today. And so the idea that, somehow that doesn't matter, it matters a whole bunch, obviously. If you told me the maximum you could get is 8, but I can get you a deal where the maximum you could get is 8, that's no deal at all. And for a woman who is maintaining her innocence, and the only reason she's pleading is because her expert was denied because her attorney didn't do the job of supporting that expert? I mean, that's what happened here. We have an innocent person who's sitting in prison right now.
Did the trial court actually make a determination that the convictions didn't merge, or did merge?
The trial court made no decision on that. However, they clearly do, because there's no direct evidence of any actual action being taken. The way that they get my client is they say, well, you were the only one there, and it had to be car accident level injury, and it had to be immediately before the manifestation of symptoms, so it must have been you, right? But they don't have two separate acts. They don't have any way to prove separate things here. They have one onset of symptoms that would have merged. But here's the other thing. We were denied without a hearing, right? Any of the, and my colleague says it best. That attorney can come up and either confirm or deny what we've said. Why do we have to make a determination based on, I don't know, the trial court's reading of the text on the affidavit? It's not directly contradicted. There's nowhere in there where it says, oh yes, I was talked to about merger. Oh yes, I was talked to about the possibility of a conditional guilty plea so I could challenge the court's ruling taking out my expert. There's nothing that says that affirmatively. So the trial court reads the text and doesn't like the font, and so he says this person's not credible? That's not the way that we do business. Unless the record directly contradicts it, that affidavit has to stand. Now, my colleague cited 2 cases. Meyerson, which I did, and in Meyerson they said, well, you didn't make the allegation that you objected to your trial counsel's basically admission of your guilt. And because you didn't object to it in your affidavit is not sufficient. That's not saying we discounted everything you said. That's saying instead, you didn't say the things that you needed to say. That's not the case here. They're not saying that. They basically implicitly admit that if these claims were true, that they would demand a new trial. The trial court says, seemingly says that, implicitly says that by failing to say, there's 2 prongs, right? One is, do you have a substantial claim? Not a jelly donut claim. I didn't get a jelly donut at trial. It doesn't matter if you can prove that. That's not something you get relief on. These are not jelly donut claims. These are real claims. And if they are true, then they deserve relief. And we're avoiding a hearing where the trial counsel can come in and say whether it was true or not. And then the trial court can make determinations based on actually hearing from the relevant parties, not just reading a piece of paper. And I want to stress this enough in my last 10 seconds here. I do a lot of cases where the person is obviously guilty. This is a person who is not only innocent, has proclaimed it so, but we have a dot-to-dot, connect-the-dots case for why she entered that Alford plea. This is the most important case that I've done in my career, and I ask you to reverse the trial court's decision, remand for an evidentiary hearing consistent with the court's opinion. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. The clerk will mail a copy of that decision to you upon its release. The opinion will also be posted on the Supreme Court website at that time as well. With that, I'd like to thank both attorneys for their presentation this morning on